with this session, I'm going to push further into our overview of the law of torts. This is torts 3, simply from the standpoint of it's the third of the asynchronous substantive discussions of the law of torts. And with this session, we're going to look a little bit more at negligence, and I'm going to talk a little bit about the third of the categories of tort law, that which is known as strict liability in tort. And we'll talk about some of the defenses that exist also in tort cases. But as I am prone to do, I like to kind of reset the table a bit. As you've heard me say now multiple times, there is no area of law that is more subjective than the area of torts, in that particularly when you look at negligence, the concept of what is reasonable behavior, or if you will, what is unreasonable behavior, is something that is always subject to interpretation. It's subject to change as we learn more and we develop greater skills, particularly in a particular area or field of endeavor. And so while I think learning the law, it's helpful when you hear, point A, point B, point C, and then you have to apply those points. And if any of them are lacking, well, then that gives you your answer. And when we get to property law, you will see that there is nothing more mathematical in law than applying property law. But that's not the law of negligence. And certainly that's not the law of torts, where by definition, we're essentially asking the question, not what could have been done differently, but what should have been done differently. To continue with sports, in a sports analogy, to judge negligence is the quintessential Monday morning quarterbacking. We already know the outcome. We already know what happened. And now we're looking to judge whether or not the behavior was something that should have been different. There's never been an accident, or there's never been, a crash or harm where we haven't looked and said, boy, I wish we could do that differently. But when you're looking at judging what is or what is not negligent behavior, you have to really focus in on that moment right before impact, that moment right before the crash, that moment right before something bad occurred. And you have to think about what should have been done differently. One of the things that I think is always important to remember also when assessing negligence in particular and liability, when you're looking at it within industry, when you're looking at it in a business, you have to look at that behavior. You have to judge that behavior, knowing that someone is always able to come up with what could have been done differently, but you have to judge that behavior in the context of what was known at the time. And you have to always remember that in a negligence case, the burden of persuasion, remember that term, the burden of persuasion is on the plaintiff. The burden of persuasion is on the injured party. The burden of persuasion is upon those who are bringing the lawsuit, the plaintiff, to establish that the defendant has acted negligently. One of the things that we'll talk about when we look particularly at the risks that businesses face, and I did defense work for about 9 years straight, representing firms that insured retail businesses, restaurants, hotels. And one of the things that we would talk about in those circumstances was the fact that it was the responsibility of the plaintiff to show and establish how the defendant had acted negligently, not the other way around. And one of the things that was always problematic in defending cases was the fact that a restaurant or a hotel or a retail establishment, when there was an injury on premises, would write up a relatively detailed analysis of what had happened. And I'd have the manager outlining in writing what it was that they had done wrong. And um, this became problematic when there was then a lawsuit and there was a document that was prepared by my client's manager who had perhaps not even seen what had happened, but had already made the determination that we were at fault. It certainly made negotiating resolution of those cases a little bit more challenging. It certainly made winning those cases more challenging. And so when we talked about business strategies, we would talk about how to fill out a report, getting someone's name, getting some of the facts of what was the underlying events that gave rise to the incident, but not drawing a legal conclusion, particularly somebody that wasn't present. Of course, the natural inclination for certain managers was, wow, if this was a report that hurt us, we better get rid of it. And that's problematic on multiple levels, including the fact that it can be a crime it depends upon the circumstances, certainly, but to get rid of evidence, it's fraud. And when somebody thinks that they're helping by somehow making a report disappear, not only are they not helping, but in most states there are jury instructions that if a document did exist and then it no longer exists, that can be presumed to be something that was very detrimental to the holder of that document, to the defendant. When we looked at intentional torts, I had outlined for you that intentional torts really mirrored crimes. The focus, of course, being different. The focus of the intentional tort to compensate the victim of intentional wrongdoing for that which had been done to them. But the elements that needed to be established for an intentional tort to exist, assault, battery, false imprisonment, defamation, some of the intentional torts that we talked about, were pretty specific. And the questions that were asked of jurors were again, pretty specific when it's an intentional tort. With negligence, it's so much broader of a concept. What is reasonable behavior? What would a reasonably prudent person have done under the same or similar circumstances? The best that we can offer are those four elements: duty, breach of duty, causation, damage, and ask juries to apply those four elements to a particular set of fact. As I indicated during our previous session, the issue of duty, one that is fairly well established by law, and in tort cases, an issue that the court will typically rule upon before allowing the case to get to the jury for the resolution of the questions: breach of duty, causation, and damage. But as I indicated to you previously, you can almost look at any particular circumstance that results in injury, that results in harm, and you can backtrack and try to apply those elements to see if, in fact, the tort of negligence is a possibility. One of the concepts that we have talked about that I think is important, again, to recognize when looking at the law of torts is: how is the legal relationship between the parties to a case established? What is the basis of that legal relationship? If the basis of the legal relationship is contractual, and the harm that results from unlawful conduct is merely a breach of contract, then the remedy is limited, as we've talked about, to economic damages. We'll talk about that again soon when we look at workers' compensation and when we look at the No-Fault Act. It is when the relationship between the parties is not just simply grounded in contract, but extends to the area covered by the overall general obligation, the general duty, the general standard of care that applies to all of us when it is our behavior, our conduct, our products that put others at risk of harm. There was a case back in the early 20th century known as McPherson versus Buick Motor Car Company. McPherson versus Buick Motor Car Company, one of the more famous cases in the history of tort law. And under the facts of the McPherson case, there was a plaintiff, McPherson, who was riding in the front seat of an automobile that McPherson had not purchased. And there was a problem with the wheel, and McPherson was thrown from the vehicle and injured. And McPherson brought a claim of negligence against Buick, the manufacturer, designer of the car. And the defense that Buick offered at that time was, we didn't sell the car to McPherson. McPherson was not a customer of ours. And in a significant tort decision, the court in McPherson ruled that you didn't have to be in privity of contract to be liable for your behavior, for your actions. You can think of that same concept as being applicable when a bar sells alcohol. The fact is that someone can be harmed as a result of the negligence in the manner upon which the bar has provided alcohol. If the bar provides alcohol to a minor, if the bar provides alcohol to a visibly intoxicated person, and that minor or that visibly intoxicated person goes out and harms someone, that person that is harmed may never have even known what happened to them, particularly if it's an automobile a drunk driving crash. But that victim, who perhaps has never even heard of the establishment that sold the alcohol to the visibly intoxicated person or to the minor, that victim or that victim's family nevertheless has a tort action under what we call, in those circumstances, the dram shop laws against the provider of that alcohol. We no longer require there to be privity of contract for a tort case to exist. We look at the behavior of the alleged wrongdoer, and we look to see if it is reasonably foreseeable that that behavior could cause harm to the person or entity that is claiming that they are harmed as a result of that behavior. This is the zone of danger. Is it reasonably foreseeable that my unreasonable conduct could cause you harm? If so, then I owe you a legal duty. Now, this concept of legal duty doesn't extend to trespassers. It doesn't extend to people that should know better. You have, and by the way, when I give examples like this, you may want to pay a little bit of attention because the examples have a tendency to come back on exams from time to time, at least. You own a facility or you own a home and you have a swimming pool. And we recognize that the law requires that the entity or person that owns or controls a pool has to have that pool fenced in. And I, your law professor, come upon your property, and I notice that the pool isn't fenced in. And so I, your law professor, decide it's kind of a warm day out. I'd like to take a little dip in the pool, and I run and I jump into your pool only to find that there is not enough water and I am injured. Now, shame on you for not having the pool properly fenced. That's a violation of the law. You could receive an ordinance violation. But the fact that you should have had your pool fenced in is not sufficient, and didn't have your pool fenced in is insufficient to allow me, your middle-aged law professor who should know better, a cause of action because I run and jump into a pool. I am a trespasser. No duty is owed to me as a trespasser. There was a case some years ago where a man owned a home, and he knew that some of the neighbor kids were breaking into the home and engaging in some questionable behavior over and above breaking into the home. And so the man was angry that people were breaking into his home and engaging in that behavior. And so he booby-trapped the home so that the next person that would come in would get seriously injured or killed. And that's what happened. And a 12-year-old or 13-year-old child went into the home and was killed. In that particular circumstance, the defense of, but that was a trespasser, didn't apply. And in fact, there was a prosecution for the reason being that you don't have the lawful right to hurt someone simply because you don't like the manner upon which they are engaging in behavior. He wasn't there. This wasn't one of those even arguable cases upon which he was trying to protect himself or his family. He just didn't like the fact that when he wasn't at the home, that some of the neighbor kids were breaking into the home. That didn't give him the right to take the law into his own hands and to hurt someone. Is it reasonably foreseeable that our unreasonable conduct could cause harm to another? If the answer is yes, then the element of duty has been satisfied. And we then move into the question of breach of duty or unreasonable behavior, cause and effect between the breach of duty and harm, and objective evidence of harm. Duty, breach of duty, causation, damage, the four elements to the tort of negligence. Now, in the law of negligence, there are different areas of the law of negligence that we might apply slightly different rules to depending upon the subject matter or whom it is that has allegedly committed negligence. By way of example, when a physician or a hospital has allegedly committed the tort of negligence, unreasonable conduct, behavior that dips below that which is expected of a physician or a hospital. What is the minimum level of acceptable care? Was that met? Was that satisfied? In circumstances where you have a physician or a hospital involved, or if there is a product that is allegedly been designed or manufactured negligently, we'll apply slightly different rules, again, while the main issue is still fault, negligence. By way of example, in most states, including Michigan, if you are alleging medical malpractice, negligence on the part of a physician or a hospital or somebody in the medical community, in those particular cases, you have a shorter statute of limitations than traditional negligence. Traditional negligence in Michigan is a 3-year statute of limitations. It's a 2-year statute of limitations if it's malpractice on the part of a physician. And you have to actually have some person who shares the same degree, some person who has the same specialty as the physician who has allegedly committed malpractice, certify that there is legitimacy or merit to the claim. So if you have a person who has a particular area of expertise, it's not sufficient that a jury or a judge think, well, that was malpractice. You actually have to have an expert. You have to have someone who will qualify to observe the behavior of that physician and certify that that behavior was negligent, that that behavior dipped below that which is the acceptable standard of care for the community. In many circumstances, particularly involving specialty areas like the practice of medicine or like the designing and manufacturing of products, many states have put caps on the amount of non-economic damages that can be recovered even when there is negligence. Most states on medical malpractice have put in caps of roughly $1.5 million in non-economic damages. And the threshold is even a little bit lower for the caps in most states as it relates to product failure, product liability issues. Product liability is a subclassification, if you will, within the tort of negligence. And here, of course, the issue is, was there product negligence? And product negligence can occur in one of three different ways. That there is some deficiency in the way that the product was manufactured, that there is a design deficiency, or that the product should have contained a warning and it was reasonable to believe that without the warning, someone would have used the product other than how it was designed and been injured. This is where you will get, by way of example, warnings on ladders, don't go beyond this step. Or you will find when you get into a vehicle, warnings about the airbag being present and whether or not it would fire if there is a child in the front of the vehicle. The proliferation, if you will, of warning labels are largely to ward off the potential of negligence claims against how products are used, so that you can eliminate the failure to warn claim of negligence on the part of the product that has brought about injury to a person. So when you hear again the term product liability, think to yourself, well, that's a tort claim. Somebody is claiming that they were injured as a result of the use of a product, and that tort claim is more specifically, was there negligence in the manufacturing or in the design or in the reasonable use of the product? Let's look at the defenses that exist to a claim of negligence. Simply because one has engaged in faulty conduct, somebody is engaged in behavior that dips below that which is deemed reasonably mandated of them. What is the minimum level of care? What is the minimum level of behavior that we will accept? And this was conduct that dipped below that minimum level of behavior. And I would think, by way of example, let me give you an example. You operate a hotel, And in the lobby of that hotel, someone spills a beverage. And that beverage is allowed to sit and not be cleaned up. And it can be shown, perhaps through surveillance tapes, um, that that beverage remained on the floor for 48 minutes. And through the course of that 48 minutes, maybe dozens of people traversed the lobby area until one of them unfortunately hit that liquid in the right spot and fell and was injured. What is the reasonable period of time to clean up a spill if you are an invitee, if you are making money off of people coming to your locale? 15 minutes, 30 minutes? Now, if the plaintiff is unable to show how long the condition was as it is, it's going to be very difficult for the plaintiff to prevail. And that case is likely to be dismissed. But if the plaintiff's able to show the water was there for 45 minutes, the liquid was on the ground for 45 minutes, the question then becomes, what would have been a reasonable period of time for the hotel to have cleaned up that spill? That's basically the issue of, was there a breach of duty? Even in those circumstances, it is certainly possible that a jury might say, yes, the hotel was at fault, but we also think that the person who slipped and fell on that liquid is also partly at fault. Now, historically, if it was found that the plaintiff was at all at fault for his or her accident, if the plaintiff was at all at fault for his or her accident, in other words, I fall, it's your fault, but it's 1% my fault. If I am even 1% at fault, historically, that was a bar to my recovering any damages for you being 99% at fault, me being 1% at fault. This was the doctrine of contributory negligence. And if the plaintiff was found to be at all responsible for his or her accident, this was a complete bar to recovery. This has been replaced in every state by what we refer to now as the doctrine of comparative fault. And this is important to understand because it illustrates two things. Number one, when we determine someone is at fault for harming another, and they had an obligation to act with reasonable care for the safety of that other, and they breached that obligation to the other. When we make the determination that there is negligence, they don't have to be the only person that is at fault. There might be multiple, what we call tortfeasors. There may be multiple parties that are responsible. And even the plaintiff themselves might be partly responsible. And what we'll ask juries to determine is, first and foremost, was the defendant at fault? Did the defendant act negligently? What is the harm that was sustained by the injured party, by the plaintiff? What's the value that we put on their loss, both economic and non-economic loss? If it's a broken bone, what are the medical bills? What are the necessity for lost time at work? What is the pain and suffering worth? But we will also ask the jury to determine if the plaintiff is also partly responsible and what percentage we would assign to the plaintiff responsibility for the accident that has happened. I remember a case once that happened here in Lansing. I was not a lawyer at the time the case happened, but there was an elderly woman who was living in a home, and some workmen were doing some construction work around the house, and they clipped one of the gas lines, and they heard that hissing sound, and they realized there's going to be an explosion, and they ran into the house and they grabbed the elderly woman and they carried her out of the house. And of course, she was in her nightgown. The neighbors were around and she was embarrassed. And so when nobody was looking, she went back into the house because she wanted to actually get more clothing. Well, when she was back in the house, there was an explosion and she was thrown from the house back out into the front yard. Fortunately, she did not suffer any serious injuries. Some bumps and bruises, some scarring, and the house, of course, was a near total disaster. And I remember the plaintiff's lawyer being quoted in the case because when asked about the damages that his client had sustained, obviously other than the loss of the contents of the house, I remember the plaintiff's lawyer exclaiming, well, the ride had to be worth something. And I do recall that there was a settlement, and in fact, the company that was responsible for clipping the gas line did pay the woman for the ride that she had taken out of the house. Not a whole heck of a lot of money. I know that. I always found it interesting that they settled the case because I would have been fascinated at what the jury would have concluded was the comparative fault for the woman who had gone back into the house. I suspect that for at least her physical injuries, the jury would have put more than 50% of the responsibility on her since they had gotten her out of the house. And under Michigan law, that would have resulted in an absolute bar of her recovering anything for pain and suffering. Here you see a comparative fault chart, and you can kind of picture how it works. But the whole idea is that if the plaintiff is found to be partly responsible for his or her own accident, that doesn't mean that the defendant is off the hook for the negligence that the defendant has engaged in, but it does allow for whatever the jury determines the plaintiff to be entitled by way of damages. It allows for the defendant to be able to offset by the percentage attributable to the plaintiff's fault the damages that the plaintiff is to recover. I don't expect you to know the concept of modified comparative negligence, although I will say for those of you that are interested, Michigan is a modified comparative negligence state in as much as once the plaintiff is 50% at fault for his or her own accident, the plaintiff is unable to recover for non-economic damages or in other words, pain and suffering. But I can tell you in all of the years that I have practiced law, I have never once personally seen or been involved in a case where a jury has felt that the plaintiff is 50% at fault or more and has awarded the plaintiff anything. Usually once the jury in their own mind thinks that the plaintiff is more at fault for the accident than anyone else, juries will usually rule against plaintiffs and enter what are referred to as no cause of action verdicts. There are certain defenses that exist to claims of negligence. One of the more commonly used defenses is that the plaintiff, the party that is injured or claiming injury, voluntarily assumed a risk by engaging in behavior, or that the risk was open and obvious. When I started going to Major League Baseball games, my favorite ballpark was Tiger Stadium down in downtown Detroit. And the very first time I attended a game at Tiger Stadium, I remember watching a couple of people get hit by foul balls that left the playing field. There was a small screen behind the home plate area, and a lot of balls went into the stands. And of course, as a kid, I was always trying to run down and grab one of those foul balls. But over the course of years, we have seen the netting extended quite far along the first and third base lines to protect people who are at games. And this is as a result of cases that have been filed against Major League Baseball teams. The defense that the teams would offer was, hey, this is an assumption of risk. When you buy your ticket, you know that the ball is going to leave the playing field. And yet, more and more, as balls leave the playing field at a faster rate of speed, more and more as there are distractions through advertisements within stadiums, more and more there is the recognition that it's quite easy for this risk to be minimized by just simply putting up a net. I happen to be at the very first game ever played at Mon Arena, and I know for certain that there were absolutely no nets around the Mon Arena rink protecting anyone in the stands. Pucks would frequently leave the ice surface, and now most pucks that leave the ice surface run into nets, and patrons are protected. So the fact that there might be risk assumed in an activity doesn't completely shift the responsibility away from the would-be defendant and onto the plaintiff in a particular area or endeavor. One of the more interesting defenses that exist that I bring to your attention is at the bottom, governmental immunity. From the earliest days of the common law in England, the rule of law has traditionally been that to sue the crown, you must have permission of the crown. Bring that to modern day, since the ability to file a lawsuit is availing ourselves of the courts, the government sponsored areas for the resolution of disputes. If you're going to have the right to sue the government, you can only have that right with the approval, the consent of government. And so the starting point with regards to government is that government itself is immune from civil lawsuit. The actors, the individuals, are not immune. In fact, when Michigan State University is the subject of litigation, quite frankly, what you will see is not the university itself sued, but the members of the board of trustees or the president will be sued, because Michigan State University is a governmental entity. Now, there are exceptions to governmental immunity, and those exceptions to governmental immunity, or where the government has actually said by law, here's where you can file a civil lawsuit against the government, are found by various code statutes that break out when you actually can sue government. And in Michigan, there are 5 different circumstances upon which the state of Michigan has said you are permitted to sue the government for negligence or contract claims in these particular circumstances. Failure to maintain and repair highways, negligent operation of vehicles, dangerous or defective conditions in public buildings, the performance of a proprietary function, or in other words, a business function, and the ownership or operation of government hospitals. But for these 5 classifications, if you try to bring a tort claim against the government, you're going to fail. Which brings us now to the third and final classification of tort, and that is what we call strict liability. Strict liability. Strict liability is a anomaly a bit in the area of tort law, in that strict liability cases are cases where we will start with the presumption that there has been damage, and we will start with the presumption that the entity or person who has caused that damage is going to be responsible. There is not the necessity of establishing fault. When someone is engaged in abnormally dangerous activities, when somebody is engaged in abnormally dangerous activities. Under the law, this presents some challenges because if somebody's by definition involved in abnormally dangerous activities, it's quite difficult to get insurance to cover those abnormally dangerous activities. And I always think when confronted with the question of what is an abnormally dangerous activity, a couple of things jump to mind. If you are involved in the production or distribution of petroleum products, that is an abnormally dangerous activity, in that if there is a spill, even through no fault of yours as the distributor or the refiner, if there is some catastrophe, if there is an accident, if there is a lightning strike, if there is a tsunami, if there is an earthquake, you might have done nothing wrong, but your product is still going to cause significant harm, at least to the property of others. Another example to me of an abnormally dangerous activity is where you have an animal that is being used in a business setting, particularly where you have an non-traditionally domesticated pet, and there is certain inherent risk to the use of an animal in those particular settings. What the idea behind strict liability is that if you're going to be performing an abnormally dangerous activity, particularly if your business model is to be engaged in an abnormally dangerous activity, you become the insurer for all those who can be harmed as a result of your decision to engage in that abnormally dangerous activity. Because there's inevitably going to be a spill, there is inevitably going to be some harm that happens at some period of time. We've seen this now most recently on the California coast, where a pipeline is ruptured and there is petroleum product that is making its way to beaches and homes and causing significant damage to those properties. How does one have adequate insurance, particularly to cover something that isn't necessarily their fault? You're the deliverer of petroleum in a truck, and through no fault of yours, you're in an accident, and your tanker spills over and destroys the land value of all and wherever the product spills. How do we deal with those types of issues? Well, this is probably an outcome that is made to fit a bad set of circumstances. The concept of strict liability is where we will say, in some circumstances, if there is harm as a result of your decision to engage in, again, abnormally dangerous conduct, then you will be responsible for the damages that are done without a determination of fault. I don't know if you've ever watched on the news when a building is imploded. If you'll ever take note to when a building is imploded, it's typically done very, very early in the morning, and rarely is there much notice given that the building is going to be imploded. Those of you that are from the Detroit area may remember a few years back when the Silverdome was taken down. Big stadium out in Pontiac. Again, very little notice given and done very, very early in the day. Because that is an abnormally dangerous activity. And if there is harm to any person, or more likely to their property, the company that has that contract bears the responsibility to compensate for the harm that is caused, even though there may not be anything that they could have done differently or should have done differently. Strict liability doesn't apply that often, but when it does, it is always the best available remedy for a plaintiff because they don't have to establish that the defendant did anything wrong. If strict liability applies, we just litigate damage, nothing by way of determining who's at fault and percentage of fault. In Michigan, some of you may be interested to know, in Michigan, we apply the concept of strict liability to dog bites. And I love dogs. And I've always had dogs. But you will hear every once in a while people make the statement, well, the first bite is free. In other words, if you didn't know that the dog had a propensity towards biting somebody, then you're not responsible for the harm that is caused if your dog bites. That's inaccurate. Now, there can always be defenses. Was the dog provoked by the person who was bit? But in Michigan, we do apply strict liability to dog bite. While I don't consider my dog to be abnormally dangerous, the law of the state of Michigan does impose upon the owner of a dog certain potential liability by the very nature of the decision to have the dog. And I'm going to keep having dogs, and I'm going to keep trying to make sure that my dog always acts appropriately. Like so many homeowners, I'm going to have liability insurance in case anything happens that gives rise to injury or harm to others. But I bring to your attention, and it's worth understanding, this third, albeit not oft used type of tort, but the tort of strict liability. So, of course, the spectrum of fault that I brought to your attention in our first session relative to the law of torts, the more intentionally bad the behavior of the wrongdoer, the less the victim needs show by way of harm to prove their case. All the way across the spectrum to strict liability, where we don't even concern ourselves with the intent of the, quote, alleged wrongdoer, end quote. But there certainly, it's all about measuring damage. That will do it for this session of torts. We will move now into an overview of some of the exceptions to fault-based liability. Amongst those, injuries that are sustained at work and injuries that occur through the use operation of motor vehicles. And then we'll conclude our overview of tort law by looking at a concept of law that is, I think, quite important to recognize for industry, for business, and that is the tort concept that we refer to as a vicarious liability, holding someone accountable for the actions of another. Direct liability, being held responsible for our own behavior. Vicarious liability, holding someone responsible for the behavior of another. Please keep well. As I mentioned at the beginning of the session, please take some time to enjoy what being a college student has to offer. And that means look after not just your physical well-being, but your mental well-being. lot of pressure, and I get it, and I understand, and I can see it, frankly, even in the form of emails that come from you. It's why I try to remind you, I guess, as often as possible during exam times, get sleep, take care of yourselves. Um, all of the pressures that I felt when I was a student were real. And to some measure, I do sometimes look back on them in context and smile a bit and recognize that, the difference between the 3.5 and the 3 point, or the difference between the 4 point and the 3.5 on various different exams or papers probably wasn't worth the angst that I put myself through. Um, Maybe some of that comes with time, but enjoy the enjoy the journey, enjoy the time that you have as a student, make the most of it, um, and recognize that there are a lot of us that do certainly see and understand and know how much of a period of anxiousness that it can be. I remember those feelings quite well. Um, they get better, I think, as you get older, but they're not necessarily fun when you're going through them. So if you feel that way, hang in there. Uh, please reach out to people that understand and get it and can help you. And please don't let a day go by where you don't reach out and try to do something thoughtful for people who don't have it as good as you. Again, a simple text, a simple hello, a simple call um, means the world to those folks, and it's going to make your day better too. I'll see you soon for what will be session 4 on torts. Stop by office hours. Let me know how I can help. Thanks.